Some of our speakers are just joining us online in time for me to turn over the chair to Wayne. Thank you.
Hello, good morning, everyone. This roundtable is a workshop on Indigenous treaties, trade, and biodiversity. And we have, without further ado, we have some initial presentation followed by some interveners that will provide some responses to that, and then we'll open it up for a discussion. So I think our first presenter is Elaina Cox. Is that correct?
I think Elaina and Eva agreed to present together.
Oh, good. Elaina and Eva are together.
One in the room, one online.
Fantastic.
And I should say actually that Elaina is actually in the room, but she's in the room at the Balsillie School of International Affairs with 12 or 15 people joining her to hear her presentation.
Fantastic.
So she's bringing in one of the other nodes who are joining us as well.
Now, Eva's just introduced herself, but I'll give a quick introduction to Elaina. Elaina Cox is currently doing her master's at the School of Environment, Enterprise and Development at the University of Waterloo. Her research interests include Indigenous conservation, environmental policy and governance, United Nations goals and targets, and ecosystem services. Elaina and Eva, the floor is yours.
Thank you. Sorry, I had to unmute myself. Can everyone hear me okay?
Yes, we can.
Awesome. Thank you. So I've had the pleasure of working with Mary Claire and Wayne and Eva on this project based on the UNDRIP, SDGs, and Indigenous Treaty innovations. So just as a quick overview, the 2015 United Nations Sustainable Development Goals have set a global agenda for development towards 2030, while the United Nations Declaration on the Rights of Indigenous People, or I'm going to call it UNDRIP because it's a mouthful, sets the standards for affirming the rights of the Indigenous peoples internationally as the world progresses along the Sustainable Development Framework. The project that we've been working on aims to analyze and dissect how the Sustainable Development Goals and UNDRIP are fostered by and intertwined with treaty implementation, primarily through the lens of Canada's modern treaties with Indigenous rights holders. So as you can see, there are so many national, international treaties and regimes that already exist that overlap with the Sustainable Development Goals that were only developed in 2015. And this counts for all 17 goals. As you can see, there is the Universal Declaration of Human Rights in 1948. That was so long before the Sustainable Development Goals were even created. So there's a basic legal framework here in Canada for Aboriginal rights and title that are largely governed through three legal mechanisms. First of all, being the Constitution, rights are recognized and affirmed by Section 35 of the Constitution Act in 1982, and this includes Aboriginal title to land, self-government, and cultural rights, which is actually, they've mainly been confirmed through court cases. And also there's, of course, the Indian Act, controversial, of 1876, which defines who is an Indian. It regulates band membership and government, taxation, lands, resources, money management, among many other matters. This act was founded on the premise of assimilation and the control of First Nations people in Canada by the Crown, but nonetheless, it still provides legal protections for First Nation rights. And of course, then there are treaties. In Canada, we have made them into historic and modern treaties. We'll get more into modern, which is what we've been working on more for this project. They provide an inherent Aboriginal right and are further augmented by historic and modern treaty agreements. And each treaty includes variations that are reflective of large negotiations between Indigenous and government signatories, which could include the Crown, the federal government, and as well, there's provinces. So they include specific benefits and legally binding obligations that the government must fulfill. A main part of this project, and of course, formally introduced in UNDRIP and ILO 169, free, prior, and informed consent is integral to upholding Indigenous rights and ensuring the effective participation in decision-making. It's a prerequisite step to relocating Indigenous peoples, implementing new development projects, administering laws, and protecting Indigenous lands from hazardous materials. Extractive economies, especially Canada and the US, New Zealand, Australia, which were the countries that actually voted against UNDRIP originally, are a large part concerned over the concerns of relinquishing this power from free, prior, and informed consent for decisions regarding natural resources and land use. So free, prior, and informed consent, free meaning that consent is given voluntarily, no coercion, no intimidation or manipulation, free. Prior, consent is sought sufficiently in advance before starting activities such as natural resource extraction or taking over land. And informed means sufficient information is provided when seeking and throughout the decision-making process. Keyword there, throughout. And consent is a collective decision reached through customary decision-making processes. So this project has been focusing on modern treaties in Canada. Canada currently has 25 modern treaties, and these are also known as comprehensive land claim agreements. And they started with Indigenous peoples post-1973 and began after the Supreme Court of Canada recognized Aboriginal rights for the first time in popular court case, Calder et al. Versus Attorney General of British Columbia. Modern treaties have provided Indigenous people with ownership of over 600,000 square kilometers of land, capital transfers of $3.2 billion, protection for traditional ways of life, access to resource development opportunities, participation in land and resource management decisions, certainty of respect and land rights in around 40% of Canada's landmass, and associated self-government rights are included in most modern treaties, and political recognition. So as you can see, there are 25 modern treaties in Canada, which we actually have reviewed them to come up with examples, which I'll show you next, that have to do with the Sustainable Development Goals, or next after this. So Canada has been progressing towards the Sustainable Development Goals, and they can do that through the eyes of modern treaties. Indigenous treaties within Canada, specifically our modern treaties, integrate Sustainable Development Goals and UNDRIP principles already. Our project seeks to analyze how modern treaties can identify how Canada's can progress in achieving Sustainable Development Goals and targets, and how they're fostered or frustrated through the implementation of these treaty agreements. The following slides will provide some preliminary examples to show you what we mean by this. And of course, while we were reviewing the modern treaties for this project, we looked at them through the scope of the three pillars of sustainable development: the economy, society, and the environment. So I'll just give you a few examples of what we are talking about here. So for example, Treaty Clause on the Champagne and Anishinaabeg First Nations Final Agreement. It largely correlates to Target 13.2 on integrating climate change measures into national policies, strategies, and planning. Specifically, Chapter 18, 2.6.3, on ending its use of quarry, government shall, if required by the affected Yukon First Nation, restore the quarry in accordance with commonly accepted land use standards, including as appropriate cleanup, drainage, erosion control, recontouring, overburden replacement, and replanting of vegetation so the quarry will blend in with local landscape and vegetation. As we know, biodiversity largely correlates to climate change, and climate change measures, including, as Target 13.2 points out, national policy, strategies, and planning. This accounts for planning as replenishing local landscape and vegetation. Another example is Target 14.4 from Life Below Water. The Tsawwassen First Nation Final Agreement has many articles that have to do with the Joint Fishery Committee, including how the Joint Fishery Committee representatives will seek to operate consensus and working towards the responsible functions and activities in respect of fishery matters managed by Canada. A final example is Target 15.1 for life on land, ensuring conservation, restoration, and sustainable use of terrestrial and inland freshwater ecosystems and their services. And another great example from Tsawwassen First Nation final agreement is the Tsawwassen First Nation may establish programs consistent with provincial programs to require the training for Tsawwassen members who harvest under the Tsawwassen right to harvest wildlife in respect of conservation and safety and methods of harvesting and handling wildlife. The conclusion of these is that they're all fostering Canada's progress towards the Sustainable Development Goals. I'll pass it on to you, Ava.
Thank you, Elaina. That was a really great summary of the work that we are doing. To take it from the examples that Elaina provided, I'll be doing a little bit of an introduction in terms of what the outcomes of our analysis are, as well as how that applies to the laws that are being created today. So in terms of the preliminary conclusions of our analysis, since we are still mid-project, we have identified, as Elaina explained, many examples throughout these treaties where sustainable development goals are clearly trying to be fostered by these Indigenous peoples as they pursue land claims and beneficiary agreements. However, as Christina mentioned earlier today in our welcome ceremony, as well as numerous reports from the Auditor General of the UN, as well as the UN Special Rapporteur, not all legal agreements end up being implemented in its fullest. There are still many boundaries that are faced by Indigenous peoples in terms of actually achieving these sustainable development goals. So at the end of the day, when we are analyzing these treaties, we not only need to look at what is stipulated within them, but also what are the next steps to honor them and the legal obligations that governments and citizens overall need to oblige by in order to make these sustainable development goals come true. One recent example of how we are failing our Indigenous peoples, as well as the legal agreements that we are supposed to honor. In September, for example, the Lonzo K First Nations, the Dene in the Northwest Territories had a culture camp that was raided by the NWT government. There was a tip-off saying that there was illegal caribou hunting in a protected area, but under the treaty rights that they had under their land claims agreements, they were doing nothing wrong. It ended up going to the courts. The courts threw it out, saying that the government was in clear violation of Indigenous treaty rights. And yet these sorts of acts keep continuing, keep persisting, even though we know that the Indigenous peoples there are honoring the regulations that are being put in place, are honoring the restrictions as well on their hunting and traditional practices in order to protect biodiversity and to further their landscape and their people and their cultural practices. So there's still a lot that needs to be done. And it's not vaguely even close to the only example of this. In 2015, for instance, Nunavut Tugamvik, the organization that represents a Nunavut beneficiary agreement, settled a $250 million lawsuit with the government of Canada over their land claims implementation. Likewise, the Supreme Court also ruled in favor of the Indigenous Party for the Peel Watershed River Project, which I'm sure many of us have seen on the news as Canadians in terms of the disputes there in terms of natural resource exploitation. But nonetheless, this is to say that there is still a lot of hope in terms of what we can learn from these agreements. There are other treaties in other countries that are being implemented, both at domestic levels between Indigenous people and their state or nation state, as well as international treaties between Indigenous peoples themselves that help incorporate these types of clauses to advance sustainable development goals as well as UNDRIP, and also further their participation in sustainable development in an autonomous and self-governing way. For instance, Wayne later will be speaking to IPETCA, which enables Indigenous economic development and self-government, where Indigenous people are taking the reins in terms of negotiating trade agreements and furthering their autonomy, their Indigenous knowledge, their traditional knowledge, and essentially like giving power back to the people in that sense. For example, like other agreements that we are going to be analyzing through this project include McCurt v. Oklahoma in the United States, as well as the New Zealand Treaty of Watagani, and also agreements in the Andes between Chile and Bolivia, all of which provide very innovative, unique methods to achieving sustainable development goals for Indigenous peoples themselves. And like I said, there are other ways to implement the lessons learned in the project that we are analyzing itself. The lessons that we learned from this project itself can be implemented in other forms of government policy. Mr. Van Buchanan in the previous session that was in this room also noted that there is a need to couple policymakers and lawyers as well in the actual implementation of these biodiversity and sustainable development and various international frameworks. There's a collaboration that is required, and a lot of the information that we're gaining through this project, we hope will be implemented in such ways as well. Some examples of what we have identified in terms of protocols and treaties that are demonstrating the goals that have set out. For example, the treaties have been in clear demonstration of some of the elements of the Kyoto Protocol. One example that we found in terms of specifically biodiversity and traditional knowledge was in chapter 10.43E of the Swasin First Nations Agreement in relation to wildlife harvesting and traditional practice as well. So there's a clear integration between these international mechanisms as well as the efforts to advance sustainable development, both domestically from a government's perspective, but most importantly through an Indigenous First Peoples perspective as well. And then finally, there is an amazing, innovative approach that is being developed. As I mentioned earlier, Wayne Garnons-Williams, who is sitting beside me, and I am honored to work with him as well, is at the front lines of developing innovative ways to approach self-government, trade, economic development, as well as sustainable development for Indigenous peoples. So here we have a little bit of an introduction into the vast amount of work that he does. And he is always very excited to speak about this as well. So I'm going to pass the floor to you and you can take on from there.
Thank you, Ava. Thank you, Elaina. Really great job. Hello, everyone. I'll be very brief, but I want to talk to you today about IPETCA, the Indigenous Peoples Economic Trade Arrangement. Now, it's not an agreement, it's an arrangement between 4 nation states and growing. There's Canada, Australia, New Zealand, and Chinese Taipei. And the cool thing about this is, unlike other trade negotiations, this dealt with Indigenous trade to Indigenous trade. And unlike other trade negotiations where the nation state representatives from their respective departmental experts would be directly involved, well, Indigenous people were directly involved as well in the negotiations. So I got the honor and the privilege of being the chief negotiator for the Canadian Indigenous group. And we worked with our brothers and sisters from the other Indigenous nations that are parties to this. And the way it worked is we were able to come up with consensus building on impasses that the nation states had tripped over. And we could negotiate something that made sense from our Indigenous philosophies, Indigenous laws, and then reach that consensus and bring it forward. So some of the cool things, and this is, there's 4 things that are really cool about this. One, first time ever, there's a definition that's recognized by 4 nation states and growing of what is Indigenous trade. And that's really exciting. I'm not going to read the whole thing, but just go to it if you want to know about it. The second thing that is important here for this discussion here is that there's an emphasis on environmental protection in IPETCA. And all the parties to the arrangement within the documents, written in the document, acknowledge the importance of the significant international environmental agreements, including listing them, the UN 2030 Agenda on Sustainable Development Goals, the UN Financing for Development of Addis Ababa Action Agenda, the UN Financing Convention on Climate Change, the Paris Agreement, and here's the one that's important for this discussion, the Convention on Biological Diversity, as well as the UN Convention to Combat Desertification, and the Convention on the International Trade of Endangered Species. So all of these are reminders that this is a philosophy, a different way of doing trade. It's a way that doesn't just focus on the bottom line or satisfying shareholders, but it takes an indigenous philosophy of being part of nature, not being on top of it, but being within it and respecting the ecosystem when you harvest. And it's other aspects of the philosophy is to give back, not just to take, but to give back to the environment so that we can all live for the benefit from it, but as well, the seventh generation will also equally benefit from it in the future. So it's a groundbreaking agreement for all those reasons. And as well, there's a whole bunch of business stuff that deals with actual trade matters, but I'm not going to get into that for this purpose. But that's what I want to share with you. Oh, and the last thing that's really important here is the inclusion of traditional knowledge and cultural heritage in the trade agreement. The participating economies recognize that existing international human rights obligations are interrelated, interdependent, and mutually reinforcing, and should be considered alongside each other when advancing the rights of Indigenous peoples and their participation in international Indigenous trade. So IPETCA embraces a pan-Indigenous-led philosophy of Indigenous culture, land, language, and rights that are fused to the Indigenous cultural ties with the environment. That's the most exciting thing about this. And if this works, if we can get this up and off the ground, I think it'll lead the way in showing a new way to do trade. That the old method of just reaping and harvesting without consideration, there's a better way than just doing that. So this is an exciting opportunity, and thank you for giving us some time to share this, because I just wanted to share that with you, and you can look it up online, read the whole thing if you want. It's publicly available, and I encourage you to read it, because if you read it, that's Canada's policy on Indigenous trade as well. So,
and other countries can join.
Yes, we
as long as they bring and respect that it will be Indigenous people at the table from their country.
That's right.
Yeah.
We have mechanisms in
Colombia going. The president of ILA Colombia is with us, and yeah.
we have a thing called the Partnership Council, which is basically it's again driven. It's not just Indigenous people that were in the development of negotiations, but we're now into the management of the trade agreement and the mechanism of how to work it. So Indigenous people are involved in it. For example, in the agreement, for the actual implementation, there will be a committee from each nation state, 2 government representatives and 2 Indigenous representatives from each nation state. And the 2 Indigenous representatives will be chosen by Indigenous peoples for Indigenous peoples in a mechanism that is respectful of Indigenous peoples' philosophy on how they appoint to that body. So that's exciting as well. The end result is basically two operations. One is, of course, the Partnership Council, but the other one, this is important. It's the APEC Caucus. The APEC Caucus on Indigenous trade and investment invites the world to come every year. There's an APEC conference to have this convention where the current signatories or the current nation state representatives and their Indigenous peoples will be there, but invite the world, all the APEC members to come and participate and send a delegation of Indigenous people to learn and to learn about IPETCA and the advantages and see the results that we're bringing to the table and invite them to maybe join. So it's an ongoing mechanism to get more membership into IPETCA. So it's going to be fantastic. And then once you're in, we're looking at the nuts and bolts of trade. How can we raise all the boats at once that are Indigenous so that everyone, the quality of life for Indigenous communities all around the signatory parties are benefited. That's the really exciting thing, in a way that is respectful to environmental philosophies that are ingrained in Indigenous law and philosophy. So thank you.
I get a little excited about it because it's really cool.
I think it's only correct for me to be the one to thank Eva and Elaina, whose work on Indigenous-led protected areas has dovetailed so incredibly well with this work, and most of all the investigation she's doing on the Indigenous-led protected areas in her own territory as well. And I would like to also especially thank Wayne for being not just a terrific co-leader of the project, but also for his enthusiasm and his collaboration. It is going to be fascinating to see how this study comes together. And in particular as well, the work to look at the treaties and look at the arrangements and see how the Sustainable Development Goals and the ideas behind those goals, because they didn't come from nothing, are hardwired into them. And this is binding obligations. This is not just a policy or an aspiration. These are binding obligations. And the more that we are comfortable looking at it that way and treating it with respect and treating it with an understanding of Indigenous worldview, and I think at some point the historian in Wayne is going to go back and show that just like democracy was shared with the world by the 5 nations that share around the Great Lakes area of between Canada and the US, including the Mohawk, matrilineal and matriarchal, the concept of a treaty has a long way back that it can be looked at. So what I would like to do now is to turn to Professor Lindsay Borrows, who kindly is going to expand and complement and build on some of the arguments that the 2 students have presented, and that their mentors and co-leaders have enthusiastically endorsed. And I will just say, and Lindsay is aware of this, we have quite deliberately completely inverted the order of the usual panel here. So the students present first the meat of the presentation, and then the professors and experts comment on that. It takes some brave students to be part of that, and Eva and Elaina have just been absolutely brilliant. So with that introduction, I will hand over to Wayne to introduce Lindsay, who is indeed a friend of his.
Absolutely, my pleasure. It is my distinct pleasure to introduce Professor Lindsay Borrows. She's an assistant professor at Queen's University Faculty of Law, where she teaches special topics in the field of Indigenous law. Previously, she worked as a lawyer and researcher at the Indigenous Law Research Units, University of Victoria Faculty of Law, and as a staff lawyer at West Coast Environmental Law. She provided legal support to Indigenous communities and organizations, and has worked with different legal traditions, including Anishinaabe, Denizu, Heitzlik, and I am Select Chilcotin, and there's 3 that I cannot pronounce. I apologize. Since 2014, she's co-facilitated various on-the-land community engagements, Anishinaabe law camps in partnership with different schools and communities across Ontario. Lindsay is Anishinaabe and a member of the Chippewa and of Nawash First Nation. Professor Borrows, welcome.
Miigwech, thank you so much for the introduction and for starting us off with this incredible information on the research and work that you're all doing. It's very inspiring. And there are a number of reflections that came to me as I was listening and enjoying hearing these intersections between the modern treaty process and the Sustainable Development Goals, as well as the way that trade can kind of embody and animate these different practices. So the title of this panel is Indigenous Treaties, Trade, and Biodiversity. So my comments will pick up in turn on each of these 3 ideas of treaty, trade, and biodiversity. So starting with biodiversity, I was struck listening to this presentation by Elaina and Eva of, I think, a way to frame the thesis of this research is that a key to biodiversity is legal diversity. That what the land needs is a reflection of what we need as people in our governance processes. So if we think about in Canada, there are about 12 different Indigenous language families. Within those language families, there's over 60 Indigenous languages. And if we roughly correlate a legal tradition with a linguistic tradition, we can just have a sense of how many dozens of legal orders we have operating in this country. And these modern treaties, as were presented with the Champagne and Ajac First Nation, the Tsawwassen First Nation, and the ways different provisions within these treaties are animating different elements of these sustainable development goals, reminds us that it is the Indigenous laws that are going to give life or meaning to those goals. It's also Canadian law and it's international law. So we're in this really trans-systemic space of bringing together these different traditions to figure out how it is that we can live in relationship with the earth. And different Indigenous legal scholars have suggested that a key to reconciliation is our collective reconciliation with the earth herself as well. And so in thinking about treaties as a kind of product of reconciliation, we can think about the necessity of these treaties to be speaking to ways that we can interact and be in relationship with the earth. I was also thinking about how this idea of treaties is something that is, was practiced historically by Indigenous peoples. So many of you in Montreal, it was mentioned that you're joining from Haudenosaunee territories today. Personally, I'm joining from Cataraqui or Kingston, Ontario, which is also Haudenosaunee territories, as well as Anishinaabe and Huron-Wendat territory. And so there is a treaty history that is here. And there are agreements that were made, but as was mentioned by Ava and Elaina, if something is written down at a moment in time, that's not as powerful as if it's written on our hearts, or if we have these opportunities to continually be speaking to and giving life and meaning to what it is that these goals are. So it can mean one thing on paper, but then how we actually enact it can be something that is dynamic and emergent and dependent on the context of the day and who is involved. And so I think the treaty tradition is one that is very exciting for these sustainable development goals, because it reminds us that it isn't just one frozen moment in time, but this is something that is continually growing, again, just as the plants and animals are also growing as well. So again, we see this reflection of how our laws can be guided by the earth herself. I also think about, I suppose, one last point is that treaties in many Indigenous legal traditions were not just made between people, but were also made with the earth. So or different animals or plants. So in my legal tradition, the Anishinaabe legal order, we have stories, for example, about treaties that were made a long time ago with the Hoof Nation. So these are the ungulates, the deer, the moose, the caribou. And we have stories about how it is that we're supposed to engage in the respectful taking of those animals. And it's a condition of being human that we must take from the earth in order to survive. But we can see between Canadian law and Indigenous law that the narrative foundations of what that taking looks like really varies, depending on what kind of cultural context you're coming to these conversations or practices with. And so I think about these modern treaty agreements, and when we see a sustainable development goal or something that looks like that in there, what is kind of the foundation of that is going to be these long-standing stories, songs, ceremonies, teachings from within the language that are going to inform how it is that they're enacted in practice. And we see ways that these different nations are developing their own pieces of legislation, such as mushroom harvesting permits or environmental assessment acts or ocean laws. And they're drawing from these kind of life world practices, these cultural practices, and giving them their due respect as authoritative practices that have the weight and power of law. So those are a few of my reflections that came through these wonderful presentations. And I thank you for this opportunity to learn and to think in community. Miigwech.
Thank you, Professor Borrows. I believe our next professor, who hopefully has a good connection, Dr. Odeeth Lara-Morales. Dr. Lara-Morales, are you receiving us?
She's a scholar from Mexico, and she's currently traveling between the different Indigenous communities to return the results of her research to them. Her research, her most recent research, is on pro-poor Indigenous-led tourism projects across Mexican Indigenous communities. And so she did send us a message this morning saying the area that was supposed to have Wi-Fi doesn't. and she doesn't even know if it has cell phone coverage. So it may be that she's not online, even though she may have been earlier.
So we'll park her for now. And we have an honored guest here. We have Sylvia Plain, who was asked and graciously stepped in at the last minute on the behest of Professor Borrows. Sylvia Plain, are you receiving us?
I am here.
Greetings. Hello. Welcome.
Hey, everyone. Just to be clear, I just want to know, do I got 5 or 10 minutes and we're going to shut down at 12:30? Okay, cool.
That's great.
Don't want to keep anybody. It's Saturday. Thank you to Lindsay for inviting me. This is very important discussion and event that's going on. I know several of my friends are there contributing in many different capacities. So I'm grateful to be involved. So I guess, I'll kind of explain my work, and that just kind of will give you an idea of how I try to work within treaties and international mechanisms. So I'm from Aamjiwnaang First Nation. We're in Southwestern Ontario. And so we have some overlapping pre-Confederation treaties. And also we have a treaty, we signed the Treaty of Detroit as well. So when we think about ourselves, we think about being Great Lakes people, not necessarily acknowledging the borders. And so when it comes to governance, we think about the Great Lakes region as a whole. So, I mean, where we're situated, we got 62 petrochemical plants. We're kind of in the heart of Chemical Valley. So a lot of my work and things that are on my mind are motivated by what are unfortunate human rights violations for Aamjiwnaang citizens, and trying to critique existing legislation, work within the international mechanisms to make things better, contribute what we can. And, so I do policy and international work, but I try to balance that out by what I've become as a practitioner of our Indigenous knowledge. So I have I'm a knowledge carrier of canoe building knowledge and Indigenous technology, something I've been working at. So, when we come to the tables with the government, and we're often questioned, where are your knowledge keepers? Is your science valid? How are you using it? Are you on the land? And I want to be that example of when they show up, we have a very strong implementation of our Indigenous knowledge. So I run an education program, Great Lakes Community Education Program. We're basically planting seeds and building capacity at the community level amongst the community members to implement and operationalize our Indigenous knowledge. So when people do come knocking, or there are opportunities that open up for us to be at those tables, where we can demonstrate that very strongly. So I try to work on both ends in balance, and my priorities these days are being more on the land, and I've since returned home. Today's actually the 2-year anniversary since I've moved back from Toronto. Very big change, but very grateful because I'm accessing that traditional knowledge, that intergenerational knowledge that's very important, that we carry within this region, within our families. You know, that's our science. We are the scientists, the practitioners. And so doing a lot of community work, and then also just recently working more. So I've gone to the Permanent Forum on Indigenous Issues, as well as the Expert Mechanism on the Rights of Indigenous Peoples. Just trying to get our voice heard, trying to have a seat at the table, trying to contribute and strengthen what those tools and mechanisms that already exist. And so, yeah, for myself, I just try to be everywhere because we're kind of hidden our community and kind of the health and environmental implications. And so, I mean, it's unfortunate we have to go the human rights way. Ideally, let's just strengthen the legislation. Let's make better deals. Let's keep our promises. Let's implement what was already agreed as a framework within the treaties. You know, we're not reinventing the wheel. We're just asking to follow through on the really great intentions, spirit and intent of what was put in there by our ancestors. You know, we haven't really come up with anything new. We're operating with modern science, and yeah, like Lindsay said, it's kind of based on who's in power at the time and how we're willing to bend, and where the attitudes of the status quo is unfortunate, but yeah, so those are ways that I'm trying to be involved. So yeah, very honored to have, you know, contributed to United Nations resolutions for the 77th United Nations General Assembly, the 51st Human Rights Council, and the 52nd General Assembly of the Organization of American States. So really just trying to be all out there, but I guess I'm wanting to take the opportunity to, since we're talking about, you know, and I also want to acknowledge to the students, I really like your presentation because it actually makes my life really easy to see to track the progress, and it's a really great resource. Like if I was to go to the UN or whatnot, it's just very helpful. So great work, very important. It's good to see that track progress, and that's kind of, when we go to the UN, that's kind of what we're doing, is assessing the sustainability goals and how, you know, and every country is there to report what's going on, some better ideas. So we're looking at that, but an opportunity right now for Canadians, but mostly for Indigenous people is UNDRIPA. The United Nations Declaration of the Rights of Indigenous People Act, that was passed. And so it's right now currently going through consultation, asking people's advice on how can we implement the articles of UNDRIP. So we have a opportunity, and they're looking to publish that framework in June of 2023. So there are ongoing Indigenous consultations, but I think for all Canadians, like you can go to the Justice Department website and contribute feedback. So instead of just having these kind of like theorized ideas, that we can really put some ideas on paper and maybe see something like that in the framework. So wanting to put that out there, because that's also a personal reminder for myself to do that, probably for Lindsay. I'm sure she has some really great things to contribute, but anyone on this call that's interested, I would encourage you, if you're very serious about implementing the Sustainable Development Goals, as well as UNDRIP, you know, you can plug your ideas in there. the Canadian Environmental Protection Act is currently in review. I know they're doing clause by clause next week. So there's been some ideas. And so for Indigenous peoples, it can be uncomfortable to participate in this foreign government or legislative process, but I've found a lot of power in meaning in it to be included, because oftentimes we're in a reactive mode and we just kind of deal with it. So just trying to be proactive about how we can participate, and just kind of grateful that just wanting to highlight that maybe not everyone agrees, but for me at least, I feel pretty positive about this particular government and in their commitments to real change. I've had personal interactions, and so I think we're in a really great time to take advantage of putting things, really concrete things in place for our future generations, and I'm seeing that sincerity come out of different departments and government employees. So that's really what I can offer, is to just this is what it looks like on the ground from an individual trying to contribute, utilizing the various treaties that I have, the international mechanisms, and then also trying on the ground to build capacity to be contributors and to be really strong treaty partners. So yeah, that's all I can really offer. I guess if people have questions, I'm here, but just to give you a snapshot. And yeah, thanks again, Lindsay, for asking me to participate. Happy to share. Again, I encourage looking at special rapporteur reports, any of the General Assembly, Human Rights Council, because Indigenous peoples, at least for Canada, have had the opportunity in the last few years to be asked what our position is on human rights. And so very, very interesting times. And I also know that there is a working group, because I'm on it, trying to enhance Indigenous participation at the United Nations. So having more ability to have a say, not necessarily have to work in between with Canada, potentially trying to have different voting capabilities through the mechanisms. So there is ongoing work. So that's really what it looks like to see that on the ground and to give you guys an insight as to how we're working and how we're trying to be creative as community to see everything that's put in the treaties be followed through, but also enhanced, and also using legislation and international tools to see a better future, not just for Indigenous peoples, but for everyone. So yeah, thank you guys for listening and allowing me to contribute.
Awesome. Thank you, Sylvia. That's great. Perhaps now we could open it up for a discussion.
One of the reasons that when you haven't already cooked up everything and then you're just serving it to people and they have to eat it no matter what, the opposite way of consulting, engaging, asking for advice, asking for ideas, we learn. That's what research is supposed to be about, commitment to learning. So it does fit. So I would like to also say very, very warmest thanks first to the students for an incredible presentation. Eva, Elaina, you awesome. And then also especially to Lindsay and to Sylvia. And we will take up your challenge on UNDRIPA. It behooves us on behalf of this work to comment on the new act. I'm in the end a lawyer, and I get really excited about the technical details. And so I'm really looking forward to reading through it in order to comment. And I think our project team could do that in our next workshop.
Yeah, and I know that one of the things that the federal government is doing is part of the UNDRIP Act is a legislative review of every single piece of legislation that's currently active in the federal government to see how it jives with the United Nations Declaration of the Rights of Indigenous Peoples Act, and whether or not there's any conflict or gaps. And that review is currently ongoing. And as Sylvia mentioned, there's an opportunity for you to directly engage with the parliamentarians, because they are open to receive your comments. If you see something that you think may be a gap or an opportunity, do let the Standing Committee on Justice know that you've got an idea, and shoot off your analysis, because they'd love to receive it.
Yeah, So do we have questions either online in the BSIA node or in the Cambridge node or in San Jose, Kinshasa, Dhaka, one of the other nodes? And do we have questions in the room? Because we would be very happy to hear comments and questions. So I see in the room a couple of hands. So I'm going to ask if maybe we'll start in the room, and then we will go to online with Eva's help.
I guess I'll start if I can, and this may be too technical of a question. If it is, when you can tell me that, and we can talk about it more. I'm trying to imagine, because it seems like an anathema in some ways, how IPETCA, I think that's how you say it, how that intersects with global trade treaties like the GATT and the whole suite of WTO trade systems. Is there an intersection, or are they entirely different worlds?
Part of my organization's mandate, the International Intertribal Trade and Investment Organization, is to look at the inherent right of intertribal trade that existed before the creation of the nation states of Canada, the United States, Mexico, et cetera, and to see what we can do to revive that right, which has never been expressly extinguished by case law or by legislative enactment. And what we can do to further the philosophy behind a different way of doing trade. So it's while the two run together. For example, I'm going to use the example of CNI, Chickasaw Nation Industries. Chickasaw Nation has a rather large company called Chickasaw Nation Industries. They have a diversified portfolio of products that they manufacture, everything from massive air conditioning and air filtration units for large factories to missile defense. And they do trade under the normal World Trade Organization rules. They just go out there and sell their product as a regular company selling to Germany or to South Africa or wherever. And then there's intertribal trade, which is something that is, it's not yet entirely clear where it sits, but the way I see it sitting is that it runs alongside regular World Trade Organization rules. It's very much like the problem that we're having with the World Intellectual Property Organization, WIPO, discussion on traditional knowledge in relationship to intellectual property. I always say it's like trying to fit a square peg into a round hole, because IP rules, as you know, if you want to protect a product, it's for a specific product, for a specific company, for a specific time. And that's IP protection of that company because they've invested hundreds of thousands of dollars into that product. But if you look at in traditional knowledge, it's a group right, and it starts from time immemorial and goes on in perpetuity, and it doesn't fit into the rules. And how do you make it fit? Well, you've got to run it alongside. You can't change the majority rules, but you've got to find a niche that Indigenous peoples can function and protect their own rights. So that's where opportunities for these kind of discussions are in developing systems that work alongside current larger economic systems. Thank you.
Thank you. We have one question online from Larry Swatuk of the University of Waterloo. And they ask, so many interesting ideas and initiatives, but is there any evidence of quick wins? After 30+ years of working on environmental issues in South Africa, it is painfully clear that when it comes to treaties and laws, elites lead and others fall in line. It is also very clear that particular discourses are displayed, for example, biodiversity conservation, in ways that further rather narrow orthodox agendas and interests. Benefit sharing is rare. India offers an interesting example of where Indigenous peoples succeeded in becoming stewards of forests through a rewriting of national forest law. Under the new Forest Act, so-called scheduled tribes are officially managers of forests. This happens under the previous government. Under Modi, there has been nonstop effort to rescind the Forest Act. How did this happen? Through nonstop struggle and confrontation by Indigenous groups in support of access to forests for their livelihoods. It didn't happen out of government's goodness of heart. We also have the two discussants online. I'm wondering if any of you two would like to comment on Larry Swatuk's question.
And I would like to just introduce and welcome our keynote speakers for the final plenary of the day, who are decided they chose our workshop to join since we're running as usual a little bit late. Amy Franco, we've known for many, many years. She is now the Executive Secretary of the Convention on Migratory Species. And so she's going to feel very comfortable here in a discussion of treaties. Speaking of discussion of treaties, Yvonne, we've just met and started to get to know, but she is, of course, the Secretary General of the Convention on International Trade in Endangered Species of Flora and Fauna. And so CITES, which many of us know, and so she is extremely welcome. At the back, who's joined us as well, is our other speaker, James Hardcastle, who has kindly agreed to join us to talk about some of the, there you are, innovative financial instruments that and financing options that they're working on at the IUCN. And so I think it's very, very good for them to be here. I'm not going to put you two on the spot because I know you're here in part as part of the team, but and to join us for the last 20 minutes of this discussion. And with that, I would love to go for the answer to the really excellent question from online.
It is a really excellent question. I would just like to point out that we hope to stick relatively close to the schedule so we can hear the plenaries at the end. So either Sylvia or Professor Borrows, if you could give maybe a quick 3 to 5 minute answer, that'd be really great. I know that's really tough for such an in-depth question, but we would love to hear from you, like both after this panel as well as in the future as well.
Great, I'll go to start us off. A quick response to the quick win question. I think that this very term of like a quick win is one that we really strive for these types of examples to replicate, but I think from a philosophical lens, it's important to view our governance efforts not on a linear time scale, but on a cyclical one. And the sense that, this is intergenerational work. Our ancestors have been doing this so long before us, and we're trying to create a foundation for our future generations to pick up on what we're doing as well. And so in that sense, I often think of the analogy, if anyone's a bread maker out there, of yeast. And when you're making bread, a little bit of yeast causes everything to rise. And I think about these examples that you gave, Ava and Elaina, and that Wayne gave, and Sylvia, and this idea of these Indigenous-led initiatives towards environmental sustainability and maintaining biodiversity, enhancing it, is they might be small communities, but these little bits of small community but strong community work happening all across the country and then globally, this can have a real impact and create a sense of perhaps critical yeast instead of critical mass. Or, you don't always need to have everyone doing these things, but bit by bit, it can grow into something that flourishes. So not a specific example here for you, Larry, but more of a philosophical take on your question.
I have one as well. It's maybe not a quick win right now, but it's a win that is an Indigenous compromise as a result of a negotiation that happened in New Zealand. And that's the Waitakere River Act, which basically gave the river legal standing, and that's allowed the Maori of that area to be able to speak on behalf of the river in court, so that they could prevent random acts against the river and ensure that the river's ecosystem stayed intact. And it's part of a philosophy that the Maori have, where their ancestors are in the living things and also the water itself. So it's kind of a cool concept that I think giving, and we've if you've studied any sort of environmental law, the whole concept of giving living things besides humans legal standing is something that is tantalizingly cool to work with. And it's something that I think is worthy of exploring in this day and age, where we need to have more tools at our disposal, and to have that philosophy of having the environment have a voice. When you look at it, corporations have voices, and yet they're artificial creations of fiction, and yet living things, ecosystems should have voices as well. So it's not a quick win, it's a win that's happened some time ago, but it's still winning the way I see it.
Yeah, that's a very good point. And actually, further questions in the room? Okay, let you go first. I could then add another quick win, but in a way it's an ancient quick win, if that's fair. It's about recognizing something that was already there. But first, please.
Thank you very much for the floor, Professor Marie-Claire. I have some questions regarding the presentation. I congratulate first the presenter. It was very interesting. I want to understand the concept of a modern treaty, because in the presentation, you talk about the historic and the modern treaty. I want to understand what is the temporal delineation to say that here is the modern treaty. Do you have a reference regarding the Agenda 2030, or what is the reference to conceptualize, to say that here we start with modern treaty and there is historical treaty? And my second question is about the IPETCA. The IPETCA, it's a very interesting framework. I want to know, because you say many things, positive things regarding the impact regarding the IPETCA. I want to understand what are the challenges and the next steps for the implementation of the IPETCA. And the professor Wayne talk about the possibility to engage older indigenous people or community. I noticed that in the IPETCA there are no African community. There are Canada, China, and others. So I think other continents. So I want to understand, because in the from the Congo, and we have also indigenous people in the Congo Basin. I want to know how they can. How it's possible to connect the indigenous community of the Congo Basin to the IPETCA? How is it possible, or how they, what should be the state, what they can do to engage or to be part of the IPETCA? My very last question is about the global biodiversity framework. I didn't hear any comments about how do you, what is the scenario of matching the global biodiversity framework with the IPETCA? So
those are wonderful, wonderful questions. And Blaise Pascal, the first little side comment is that we would like to be speaking more with you and with our colleagues in the DRC, including, I hope, Eric Kasongo, who is online from the CODED node. And maybe also I saw the eyes of the president of ILA Colombia shining. And I think there are some people who also might be interested in Colombia to learn more about IPETCA. What is amusing about it, of course, is that Wayne started his presentation by saying that the treaty among all the indigenous nations is growing. And I think you are giving examples of how it can grow more, which is very exciting. So I will turn, Eva, do you want me to answer about this framework of treaties in Canada, or it's a 2-sentence answer, factual?
Either one works.
I'm going to let you go first, and then I'll add anything if I have to as a good
Sounds
professor.
good. I was informed by the online moderators that we are running a little bit late and the plenary will start very, very shortly. So maybe Wayne and I could just rapid fire.
Yeah.
So to answer your question about modern treaties, it's really a delineation that's isolated in Canada and fairly technical to a new age of treaty making. Previously in Canada, we had historic treaties, either through the numbered treaty systems that went from 1 to 12 or 1 to 11, sorry, as well as the wampum belts in the areas here. There were various ways of making treaties. The modern treaty system was implemented post-1973, instigated by a case called Calder at the Supreme Court level in Canada. It essentially was motivated by hydro resource exploitation here in Quebec. And there was uproar from the Cree as well as the Inuit up in Nunavik, who needed protection for the rights of their caribou, their rivers, and their lands as it was getting exploited by the governments of Quebec and Canada.
Great. And just to answer your question with respect to the next challenges, the next challenges is the drafting of the terms of reference for the Partnership Council, which will be jointly led by Indigenous peoples and their nation state representatives, where we'll be tackling meat and potato trade issues like procurement, supply chains, foreign trade zones, responsible business conduct, Indigenous owned business versus Indigenous made goods, cross-border trade processes, and tracing of Indigenous owned products. Those kind of meat and potato subjects still need to be hashed out. So that's really exciting. And as well, I would entice you to become, have your nation state send a member to the APEC caucus on Indigenous trade and investment that happens every year, where delegates can come and join the permanent members and discuss Indigenous trade issues and see where the idea, of course, is to engage potential new members in discussion, so that then we can bring you in and make our alliance even stronger.
Thank you. That is an open invitation. I think maybe the last thing that I can add, and it is poised at the intersection between the Sustainable Development Goals and the United Nations Declaration on the Rights of Indigenous Peoples, which form the framework and the motivation for some of this research. And then the recognition of the rights that are now being enshrined, particularly in the modern treaties. As a comparative treaty analyst, when we started this project, I was very surprised that we were given the award of the Academic Council Research Grant for it, because the insight grants here in Canada and Social Science Humanities Research Council are for an established scholar of world-renowned repute, put that aside for a second, to turn her attention toward a new area of law that is different than her current specialization. I'm an international lawyer, and I'm proposing to look together with my team at treaties. Okay. Sure, really different. What I found, of course, and this goes to the heart of your question, and I think it deserves a fair answer, is that very few in Canada, until just recently in the last few years, understood that these were treaties. Thank goodness we're now recognizing it. But it turned out that that perspective of an international lawyer was actually new, which is frankly sad, maybe even disgusting, and needs work. And I think this is a space where that work is happening. It's happening with goodwill, it's happening with kindness, it's happening with the values of the Indigenous law and the recognition of Indigenous law at its core. It's happening with teams of international team members and Indigenous student team members, together with mentors and advisors and elders. And that is exactly what I find most inspiring about it. You know, the gentleman that I met in the DR Congo when we were setting up the new natural resources faculty for the University of Kisangani, he carried the constitution of his country in his jacket pocket. And he would take it out and he would say, "We committed to gender equity. I'm not a mathematician, I am a lawyer. But if we have 17 young women in our law faculty of 400 students, that's not equity. Equity should be 200. And it says so in the constitution of my country, which I fought for." That same moment happens when I'm meeting with the elders who fought for their modern treaties. They carry them in their breast pocket and they will take it out and they will say, "You care about biodiversity? See what we fought for and won in our treaty with your government." And the relevance of the convenience of the minister that wants to declare that they have decided to give charity and their schedule for that treaty relationship between those two nations should be the same as the relevance of the convenience of the government of Ecuador, who wants to meet with the government of Colombia. When we get there, we'll be looking at a more perhaps respectful relationship. When we talk about rivers having the ability to be at the table, then we're talking. And so that is what we're reaching for. It's not where we are, it's what we're reaching for. And I think that would be my only sort of real intervention and my last one, because I know that we have a plenary starting and that this has been a very exciting session. And the work, like Basil told us this morning, is only just beginning. You know, the Global Biodiversity Framework, Ohala, inshallah, is adopted at the end of these 2 weeks. And we need to be the IPETCA for law and policy, as he asked us to. We need to be ready to intervene and to help. So we'll do our best on that. Thank you.
We're done.
Yeah.
All right. Thank you very much.
Thanks, Elaina. Sylvia, thank you.
Thanks, guys. Awesome job.
And I've been informed that the moot court audiovisual is now working, so we can have our closing keynotes and plenary in the grand court. So please go straight across the hall.